I'm Roxanne Petraeus, and I'm going to be moderating this panel on AI in the workplace, exploring privilege, privacy, and risk considerations. I will say off the bat that this is a really meaty topic, and so my goal will be to try to get as much, information from our wonderful panelists as possible. And with that, I'm going to facilitate an introduction so that you can understand the perspectives and the experiences that our really distinguished panel brings today. So what I thought I would do is first starting with the ZwillGen team, I wanted to ask them what qualifies them to speak on AI. I personally know they're incredibly qualified, but obviously this is sort of a topic that is incredibly emerging, and that from even my LinkedIn post on this very webinar, I quickly learned that people have very strong opinions. And so, Brenda, would you mind kicking it off with a explanation of your experience and perspectives that you bring?
Sure, thanks. Thanks so much for having us here today. Really looking forward to the conversation. This is the most lively comment section on a LinkedIn post I've seen maybe ever. So at ZwillGen's AI division, we deal exclusively with clients using, developing, selling, operating AI in all kinds of different ways. So obviously the question of privilege comes up in a number of different contexts. What we're going to be talking about here today, of course, is if you're using AI as part of your communication channel as a lawyer or with a lawyer, does that communication retain the opportunity to be privileged? And so again, because we have looked at this in all different directions and sizes, we've had the chance to really sit down and kind of think through. Andrew is on my team there, and we'll talk more in a minute about his experience, about what the likely standards that might be applied, how courts are likely to look at this, and just really in the details of how these tools operate technically, operationally, and by policy, how they might be controlled by a client, and what guidance we would recommend in terms of optimizing the opportunity to retain privilege. So we'll see if other people agree with us or not.
We hope for lively discussion and debate, but I appreciate that context. And Andrew, do you mind similarly giving your perspectives and experience?
Sure. So another way we got involved with this issue is that as a firm, we do a lot of red teaming of large language models. And for those who don't know what red teaming is, it's essentially the way you test large language models for harms and vulnerabilities. So it usually involves like stress testing the model, throwing edge cases at them, using a number of adversarial strategies to try to like really push the guardrails to their limits and see if they hold up under scrutiny. And one of the questions we kept getting from clients on this matter when we first started was whether the memos we produce, whether the outputs we get when we test are privileged. And so that led us to do a deep dive into that issue, which, to be clear, is somewhat of a separate, distinct issue. But that led us to doing deep dives into the issue of AI and privilege more broadly. And so here we are.
Wonderful. Thank you so much for the ZwillGen team. And then finally, we're joined by Stephen Reynolds, who has extensive experience, including in the cybersecurity space. Stephen, would you mind sharing your kind of qualifications, as it were?
Sure. So I actually came in this area first before I was an attorney and a partner at a law firm. I was a software developer and an IT analyst, and most of my work is in the cybersecurity space, but there's been a lot of overlap between that and AI recently. And in addition to working with companies on cybersecurity matters, I also have litigated issues involving cybersecurity, and whether reports and documents are privileged comes up frequently, not just in cybersecurity litigation, but in others. So I've had experience in working with courts and making arguments for and against privilege in those matters.
Thank you so much. And I feel confident that I'm the least qualified person on this panel, but thankfully I'm just moderating. So with that, Ace, if you can go to the next slide, I'll frame the discussion. And these are incredibly meaty and evolving topics. And so the panelists are going to do their best to address the questions that are put in registration that will be submitted live. Feel free to use that Q&A and chat. But just note that you will almost certainly feel the need to reach out to them afterwards if you have kind of a specific question and really want to get into the details, because there just kind of isn't the space to really dive into to each nuance, and this is so particular to everyone's own situation. And then just a call out that we'll mostly be sticking to the US in terms of kind of geography, jurisdiction, but the panelists will be kind of calling out some examples of where this may vary both within the US and then, of course, internationally. In terms of kind of run of show, We'll be doing debunking some myths. I think that is a really fun place to start. Then going over some foundational concepts, some workflows and hypotheticals. And finally, we'll get into Q&A, again, both questions that were submitted ahead of time that I've got, as well as anything that you all drop into the Q&A in your Zoom app. With that, Ace, can you go to the next slide? And when we posted the session, we thought, oh, we should explain why this session. And then we had 600 plus people register. So we sort of realized, okay, perhaps it is self-evident that this is AI is already in your workflows. People have opinions, but this is like an area that is really evolving. And there's incredibly tough questions coming from leadership. You all, as kind of in-house practitioners, are being asked really tough questions to which there aren't necessarily this massive like corpus of information. And so we really wanted to provide a forum where we could get like practical, say what we know, what we don't know. And we're also really comfortable kind of acknowledging when there might be differences of opinion among lawyers. From the panelists, anything else you want to add on why you think this is an important topic for folks to at least be thinking about, if not, consulting with experts like yourselves?
I do just want to emphasize the subtext on the previous slide that said this is not legal advice. This is a discussion about legal opinions, but it is not legal advice. So following what we say we think is the rule for privilege will not protect you.
Brenda, an excellent call out. Yes, this is kind of for informational purposes, and just a strong underline that this, hopefully this will be kind of a beginning potentially of a conversation, but in no way will you walk away with the answer. So we do want you to walk away with some really tactical tips. So toward the end, we have kind of a like, okay, but what are some things I should be thinking about, even if it's not the answer? All right, with that out of the way, we thought this would just be fun. This is, there's no right answer and no purpose to this other than to get the chat kind of going to for you all to see, not from the panelists, but from participants themselves, where you may fall. If you feel so inclined to answer, just drop a yes or a no into the chat for I trust enterprise AI vendors to protect sensitive company data. Again, there's no right or wrong answer. There's no note behind the note, but it's just really interesting to see where folks fall. And I'll say, already it sort of looks like we have a consensus forming that there is some, call it distrust, some fear, some maybe very understandable concerns. With that, Ace, if you can go to the next slide, and thank you attendees for being chatty. This always makes it like a really fun kind of dialogue. We want to jump into some myths. This was, I think, really fun for me to see, because as a non-lawyer, I feel like, sometimes I see things that are shared online and very much find myself kind of wanting to ask an expert, is this true or not? And so what I'm going to do is call on some of the panelists, but of course, all panelists, feel free to unmute yourself and jump in with a myth versus reality. Andrew, starting with you, if I, as a non-lawyer, proclaim to my whole company that, putting a label on something, marking something as privileged, is the end all and be all, I have figured it out and I am done, would you say that comports with reality?
I would not say that comports with reality. So yeah, many people think that putting privilege and confidential on a document will make that document necessarily privileged, and this just isn't true. What makes a document privileged isn't what you write on top of it, it's the context of the document, it's what's in the document, and ultimately courts are going to decide what is privileged and what is not, based on a series of principles that we will cover in the next slide. This isn't to say that it's not a good practice. It is a good practice to put privileged and confidential on material you intend to be privileged, but it's certainly not determinative.
Brenda, anything to add there?
No, I think that's
Okay.
set up. I can go to the next one if you want.
Wonderful. Yeah, I just saw you come off mute, so I wanted to make sure. Okay, this next one came from me as well. And there was maybe a month or two ago, an article in TechCrunch that was kind of shared widely, at least in my circles, that was sort of a Sam Altman has determined that chatbots do not have attorney-client privilege. And Brenda, would love to get your take on, does Sam Altman, do others determine privilege? Say more on this.
So reflecting what Andrew just described, Sam Altman or anyone else putting a label or not putting a label on something does not determine whether it is privileged or not. We are here to talk about whether the use of an AI tool in the communication impacts the factors that are considered for privilege. And that's where the meat of the discussion is going to be, but definitely it isn't something that is clear going in either direction as an absolute, that it absolutely doesn't affect privilege or that it absolutely prohibits or creates privilege. The reality is that, communications with lawyers are what are potentially privileged, and the AI advice itself, if you're just asking an AI for legal opinions, would certainly not be privileged because the AI is not a lawyer. But whether it's used by lawyers, between lawyers and clients is what we'll get into. But no, Sam Altman on this, as perhaps not typical of many things, does not have the final word.
Fair. I like this. This is very clear. As for the last two, I think there's kind of a myth maybe on the more conservative end of the spectrum that if any AI tool happens to turn on or be involved in any sort of workflow that would otherwise be privileged for even a second, it is sort of ruined, that it's kind of has this like immediate impact. And Brenda, Andrew, turn it over to both of you to speak to. I know that we're going to really get into the workflows here, but if you were to debunk this myth, where would you come down?
So for the third one, I'm going to let Andrew do the fourth one at least, and weigh in on this one as well if you want. But for the third one, I think exactly with what I was just saying is that it is not categorically yes or categorically no, in our opinion, at this point. So there are, we believe, ways to use AI as tools that can still support a claim of privilege that would be upheld, but there are certainly uses that would potentially violate some of those standards. But it isn't an all or nothing that we can know going in. And maybe here's where I should say for the first time, and you already said this, Roxanne, we're not giving you definitive answers here because the truest answers that none of us actually know yet, because there's not been a claim of privilege centering on the use of AI in a way that a court has decided, at least that I'm aware of, that can start to inform our understanding of how this is going to be considered. So we are going to make our best guesses and interpretations of existing precedent, but the really true answer is none of us actually know yet.
Brenda, I found this to be a really insightful point in our prep. And so, just to kind of underscore it and tell me if I get any of this wrong, but like, this is all forward-looking projections based on, smart minds' best reasoning as to an analogy and analogous tool, for example, but that there really isn't. The reason that there's a lot of hemming and hawing or differing of opinions is in part just that this is largely an unsettled question. Is that kind of a fair characterization?
That is correct. As far as I have not seen any rulings on this.
I would trust your all's ability, though. Folks, feel free to put into the chat if you disagree, because I think that, again, the robust debate is very helpful. But our goal for kind of the remainder of this after the myth slide is to sort of use foundational principles as well as good analogies to the extent that lawyers are comfortable with a crystal ball, give you all a crystal ball. Andrew, if you could speak to the last myth, please.
Sure. So I think this is probably the single largest myth in the entire realm of attorney-client privilege, and the biggest misunderstanding of like what actually attorney-client privilege is and what purpose it serves. And so many people think that if you have certain information, internal information, and you share it with an attorney, that information is now privileged and it can't be discovered. And this just isn't true and isn't the purpose that attorney-client privilege is supposed to serve. What attorney-client privilege protects is the actual communication, those words themselves, or that email that you sent to the lawyer or that document. It doesn't protect other information that you just happen to share with a lawyer. It doesn't suddenly become privileged. The communication becomes privileged, but if that other information is otherwise discoverable, it will remain discoverable, even if you share it with a lawyer.
And Andrew, to put into, again, layperson's terms, tell me if I kind of am getting this right. If a sentence that I ideally would like to be privileged exists in a bunch of places in my company, and then I share that information with the lawyer, that information does not suddenly become privileged, just the communication that I have with the lawyer about that particular sentence does. In other words, there's no ability to put it into a magic box and take it away from all the other spots that it exists in. Wonderful. Thank you all for running through these kind of myths versus reality. And for participants who are putting stuff into Q&A, thank you so much. What I'm going to do is toward the end, we've tried to reserve at least 15 minutes, maybe even more, for these questions. So I appreciate folks putting these in. All right, we have one more ask the audience kind of question before we go to some foundational concepts. My organization already uses AI for sensitive tasks. Again, this is just a voluntary question. If you want to answer it or not, I'll say while folks are maybe thinking of their answers, that I run this company called Ethena. We do compliance training as well as hotline, case management, et cetera. And I've seen a pretty rapid adoption of AI in the legal and compliance space, much faster than I would have anticipated about even a year ago. Examples being things like use of an enterprise-wide LLM to do first drafts of investigation reports, et cetera. And so I don't come with any particular perspective here other than I'm, in particular, I think in the tech space, seeing pretty wide adoption, quote, even among legal and compliance. And here it seems like it's a little bit more mixed. All right, Stephen, we're gonna invite you and your voice into the conversation here. So would love to kind of take a step back and if you can give us some kind of foundational privilege requirements, because I think something I took away from all of our prep calls is that starting with that foundation can really help you then ask how does AI impact this? But if you don't have that foundational understanding, it becomes even more difficult to layer on AI. So Stephen, please give us a 101 education.
Yeah, sure. And so what I find that privilege, I think, can be one of the most sounds basic, but it actually can be incredibly complex in cases, and people tend to get this wrong. Even lawyers who've been practicing for years, all the time, just in general attorney-client privilege, not just specific to AI. And I think when adding another commonly misunderstood thing, which is an AI to it, you get just a more of a scenario for people to be confused. So I'm liking that we're going to kind of back up and just describe what privilege actually is. And you can read here 4 requirements here, and this is in general. And I know this varies state by state and varies if you're in federal courts, and it varies if like you're in federal court sitting in diversity. And if we get into outside US, it gets even more complicated in different jurisdictions, some that don't even really recognize privilege with communications with in-house counsel, for example, and some that generally don't really recognize privilege when you're dealing with regulatory investigations, which is kind of the primary litigation in a lot of countries. So that said, the basics are these 4 requirements: a communication, 1, made in confidence, 2, between privileged persons, the 3rd thing, and then for the purposes of legal advice. I want to kind of go in on number 3 for a second, because most of the people we work with are not individuals. They're clients that are organizations, corporations, government entities, etc. And so really understanding who is the client and who is the attorney may not be as straightforward as you think. So in a corporation, it's made up of actual individuals. You know, it's not a faceless thing, it's not a robot, it's people. In some states, there are only certain people that qualify as the client for purposes of privilege. Some states have what's called like a control group test, essentially. So, you know, if you are an executive within the company, your communications with the company's lawyer are privileged. If you are someone who may be lower level, like a receptionist or something, some states may view that communication as not privileged. That said, that doesn't mean that if someone else in the company has gotten communications from the company lawyers, it waives privilege. Waiver is a second document that we'll talk about later, but really understanding the identity of the client is very important for privilege. And then 2, the identity of the lawyer and who is the lawyer for the purpose of the communications. There was a case about 4 years ago, I think it was 4, actually maybe longer now, where an in-house attorney who was an attorney turned out to not be licensed in a particular jurisdiction where this case or matter was pending. They had just let their license lapse or something like that. And typically, you know, there are jurisdictions where you can be an in-house attorney and have an inactive license, and that's perfectly fine, not an issue. The other side in this case made an argument that all of the communications this person was a part of were waived, and they weren't an attorney and weren't privileged because they had let their license lapse for a period of time. I think ultimately the court did still find the communications privileged, but there was significant litigation, and I think a decision from a magistrate that they went to the Article 3 judge in federal court over this. So the reason why I share that example is even understanding who is the attorney and who is the client can be complicated, but these are really the foundational considerations and requirements for privilege.
Stephen, thank you for that really kind of comprehensive overview, as well as a very interesting case. And could you speak a little bit to then this idea of, you know, not to get too into AI yet, but this need to know kind of principle and how that might intersect with privilege. Again, this could be AI or non-AI. I know many people, for example, might be a Google shop or something, and like sharing and permissioning is always really thorny in organizations. Could you speak a little bit more to the risks associated with those permission settings that we all have on?
Yeah, I'll just give you kind of a practical example. So when you assert privilege in litigation, in most jurisdictions, you do this by writing what's called a privilege log. And you have to put generally what the subject of the communication was without disclosing enough information to where you've essentially revealed the communication. So it's, kind of a tricky thing. So you disclose a little bit about the communication and disclose who the parties were to the communication, and then assert what privileges you're asserting. Like it could be work product, which is another doctrine. It could be attorney-client privilege. There's insured privilege. There's accountant privilege in some jurisdictions, etc. And the reason why, like a document or some information is being withheld. When you list those privilege logs, in most places, you have to list every recipient to the communication. And I will just tell you, if you list a communication or a document or an email, and you list 30 or 40 people on the communication, your chance of a court finding that privilege diminishes by every person basically who you're including on the privilege log, because it's hard to say that you really needed 40 people to be part of this communication, and it's something that's confidential and privileged. That said, there certainly are some communications with a wide group of people and an attorney that are, but that just kind of, I think, illustrates this when a court reviews and how this works. If privilege is challenged, courts do what's called an in-camera review in most jurisdictions, where the judge looks at the privilege log and looks at the actual document without either party without the other party seeing the document, and then determines whether they accept the privilege on the document or not. And if you have these documents with a lot of people CC'd and it doesn't seem to mostly be about legal advice, and that's the other important requirement, for the purpose of rendering legal advice. So not every communication with your lawyer. I have clients all the time that email me things that have nothing to do with legal advice, right? It's great. They want to catch up with lunch, or we want to talk about sporting events or things like that. Those are not attorney-client privileged communications in most jurisdictions. My prediction of how the Jacksonville Jaguars are going to do this season has nothing to do with my legal advice. And so the reason why I point that out is because the courts are going to look at these documents, and especially if you're involved in, I do a lot of work in the cybersecurity area, there's a real question of, is this a routine communication, or is this something that's special where you brought in a lawyer to assist you with for the purposes of legal advice, or is the lawyer just acting more in a, their regular role, especially an in-house attorney, and role with the business. And again, keeping people to, it's like an information security principle, kind of a limited, people have a need to know basis on communication is really a best practice for maintaining that privilege.
Wonderful. Thank you so much, Stephen. And I'm sure we would all be interested in your sports predictions regardless, but that's very helpful. And I think that this kind of oversharing concept feeds beautifully into the next slide that, Stephen, if you're able to just kind of briefly speak to this, maybe just by doing an example, because then we'll get into workflows. So we had kind of a example, tell us if this kind of resonates. If, to your point, that draft investigation is shared with a small number of people, the correct people, but then the flip side of a risk being uploading that same draft into some sort of shared AI tool or non-AI tool, but regardless, it is accessible company-wide. Tell me if I've kind of got this right, but that really honing in on the by document permissions or by recording permissions, if we're talking about an AI transcription service or whatever, is incredibly important, because the broader those permissions are, the less likely privileges to be maintained. Do I have that right? And anything else you want to share on this concept?
Yeah, generally correct. And this is similar to need to know doctrine. So for example, if I'm interviewing a company witness or speaking with a company employee, and they're in Brazil and they speak Portuguese, I can have an interpreter, which is a third party, help me translate and understand with them. That doesn't waive privilege. But if I have other people in the room that really don't have a purpose of facilitating that communication otherwise, that may waive privilege. And the last thing I want to talk about on waiver really quickly is, in a lot of jurisdictions, it is a very harsh old legal doctrine. It is by subject matter, which means if I accidentally waive privilege on a document, like I email a document to the wrong person, I may not just lose privilege, the ability to assert privilege on that document. I may have waived privilege for the entire subject matter of whatever I'm working on. And there are some cases on this. It is harsh, where attorneys have had to provide interview notes and other things because someone leaked a document or shared one document that was privileged, and then the entire investigation or entire matter privilege is deemed waived. So it's courts, the modern trend is to not make it as harsh, but there are still some jurisdictions where waivers by subject matter, and so you have to just be extremely careful when you're sharing any kind of information regarding legal advice with a third party.
That last point is like incredibly important, and I think we'll actually kind of be able to illustrate it when we get to workflows. Is if you're able to move over there, and I think here is where we kind of like start more of the quote AI specific, but again, this can be for SaaS tools. There's a lot of principles here. What I'm going to do is Brenda ask you about the first two, and then Andrew you about the third, but Stephen jump in as well. And I'll also just say that it seems like folks found interesting the point of the translator. And so Brenda or Andrew, if you want to kind of, if you see that analogy being helpful, that may be a nice like example to bring up. But first, Brenda, I think the easiest one, a non-lawyer, so say Roxanne Petraeus, using AI. Anything you want to say about the the impact on privilege there, or whether it existed in the first place? And you're muted, Brenda. Sorry.
Just realized that as I started talking.
No worries.
But the AI was still listening, I'm sure. So to go back to the point Andrew made earlier, the information isn't privileged, the communication is, or potentially is. So if I am an HR, head of HR, and I am in the group of people, per Stephen's earlier comment, that can potentially have privilege with an in-house attorney or an outside counsel, but I am generating or doing something, doing some kind of analytics of employee performance or something over the last year, just, me doing that and then turning around and asking for legal advice about that, maybe somebody's personnel file that I'm considering needs to be put on a performance improvement plan, or that we're going to fire, and I'm going to get legal advice for that, but that doesn't turn around and then privilege everything that was existing information that I am basing my request for legal advice on. So same, consistent with the comments that we've made till now, the communication with the subsequent communication with my in-house attorney is potentially privileged. So maybe my thoughts about what we should do, or my recommendation, or things like that, might be privileged, or potentially able to be privileged, but it doesn't drag everything else into privilege with it.
Okay, very helpful. And then maybe let's go to, I think, what's going to be a more common use case given, at least for these participants here, a lot of lawyers on the call. How about a lawyer using AI? So we've got maybe an investigation first draft, some legal research. An example that comes up a ton is, reviewing contracts, client contracts, that sort of thing, MSAs. Talk to us a bit about that.
Andrew, do you want to take that one, or?
Again, I thought you were going to, but
Oh,
I'd be
okay.
happy to.
Go ahead. You go ahead.
Jump ball. Or
This is
Stephen can jump in. Yeah.
lawyer using AI. So I guess first I'd want to distinguish some of those cases there. In a second we'll address what happens when you input actually privileged material into an AI system. But if you're a lawyer and you're just using an LLM or some other AI tool to do like a first draft of a contract, or to do some legal research, and there's no privileged inputs whatsoever, there's a good chance that that use doesn't particularly affect privilege, right? Because it is ultimately the lawyer producing the document. You can think of the AI in this case as a helpful tool being used, maybe producing a first draft, maybe helping you fill in some gaps, edit some sentences. But as long as it is the lawyer's work product here, and again, I do want to specify, and as long as we're not dealing with privileged inputs, there's no particular reason I see privilege would be waived under that circumstances.
And Andrew, would the analogy here to the like translation service be helpful, or what might be a good analogy for folks to kind of understand like what AI might be acting as here?
The translation circumstances, that is a whole nother line of cases, which I mean, we can get into more detail if we want later. But
Yep.
that presents a whole nother set of implications and potential relevance. My opinion of questionable relevance here, but we'll see. What's a good example?
Someone actually put in the chat spell check, which is often what I think of, like a Grammarly or
Yeah,
something that's like running, in your office suite.
yeah, I would agree. Any kind of like automated tool a lawyer would use while working on a document, I think you can think about it like that. Of course, in this case, it's doing much more for you, but as long as it is actually the lawyer producing the final draft, then potentially should be able to have privilege on.
Okay, and then Andrew, Brenda, Stephen, really for anyone, this kind of feels relevant here. This has come up a bunch in the question. So let me throw it in here and you could tell me if you think it's kind of too early for it. But how about loading a document into an LLM because we're technically sharing it with the LLM provider, right? I think this kind of gets to the idea of training and what the enterprise settings really, whether this is an enterprise-wide license, an enterprise license or not, et cetera, et cetera. But anything any of you want to say on that? Because that is kind of a pretty frequent question we get.
So I think that kind of just brings us to the last use case here. If we just want to jump
Wonderful.
into that.
Go for it.
So I think this last one, this is the big question here. This is the one clients are coming to us the most with, and this is the one that presents the most ambiguities. And that is that whether you're a lawyer or you're not a lawyer, if you're taking documents or communications that would otherwise be privileged and you're putting them into an LLM, does that waive privilege? And so you can think here about perhaps if you're using Zoom and it has automated recording and automated AI summaries, that is taking potentially a meeting between a lawyer and a client and putting that into an AI system. Or you could think of perhaps taking an email from a client or a lawyer or a legal memo a lawyer drafted and putting it into a system for Q&A. And so doing this would be sharing the information with a third party. And as we said earlier, doing that can implicate privilege. And so that leads to the question, is privilege waived?
Wonderful. And do we, go to the next slide, Ace, please. And Brendan and Stephen, of course, jump in as well. But yes, Andrew, take us to what I think is the meat of the conversation.
Yeah, feel free to interrupt me and jump in. So the unsatisfying answer we're going to give here is that it's unclear, but no court has yet addressed this issue or come anywhere close to addressing this issue. But we can draw on some principles and some very strange case law to kind of ascertain what the answer might be. So as I just said before, the issue we're dealing with is you're taking a privileged document and you're sharing it with an AI provider, potentially a third party, and therefore you might waive privilege here. And so how would courts think through this issue? So I think the first thing I jump to is some cases from like the dawn of the internet age, where attorneys started using emails to communicate with clients, or using later on like cloud service providers. And there, courts said that that information would still be privileged, and it was a service provider, and it wouldn't waive privilege, as long as there were confidentiality assurances. And then the question is AI different? And the answer is yes, it is. So something I think maybe we've kind of touched on a little bit, but haven't really discussed yet, is the issue of training in AI. And so a lot of service providers like OpenAI with ChatGPT, they're going to be training their AI systems on user inputs to improve the service. And when AI is trained on certain information, there's always a risk that the AI is going to output or spit back that information to another user who's using the system. And that would be clear, like disclosure, not only to one party, potentially to any party. And that's a situation that could definitely waive privilege. And so we're definitely dealing with different implications here than we were in the early 2000s with email providers. And so
I want to, I just want to jump in to double down on what points you just made. For the subject of email, for anybody who's been practicing for a while, I don't want to date myself or age myself too much here. This was really, really contentious early on, was that if Google or Hotmail or AOL was the provider, I think really actually predates Google probably, were the provider of your email, how could it retain privilege? Because it was, on the server and in the possession of this provider. But because of the terms and rules and expectations that eventually worked their way into the contracts of you as a user of email, especially if you are using enterprise version email, not like Gmail, but your own proprietary Office version of a Google provided or Yahoo provided or whatever email, that the terms limited the provider's ability to see that content, and therefore courts ruled that it could retain privilege between attorney and client, assuming all other factors still applied. So that was one question. And then to the example that's on the right here, what you do with it internally also still impacts it. So even if it's privileged as regards to the platform or service, this point is that how you handle that email, who has access to it, where does it go? Is it like putting it you know, on a table in a stack of folders, or, you know, in somebody's hands who has access to all of these emails, in which case it could very potentially waive privilege, or is it handled in a secured manner internally within the company? And I think these are really good things for us to look at relative to AI. AI gets a lot more complicated than email because of the ability of the system to use the information differently, that it is going to be potentially used or accessed. It is generating some of the content. So it's definitely more complicated. But I think these are important things to consider in terms of, just because there is this enterprise provider out there as part of the process, it doesn't immediately, this is why way back at the beginning, the myth was using it at all immediately waives privilege. No, because we think no, because we've already addressed these questions in terms of this kind of technology provider, and said there is at least the potential for privilege to be retained.
Brenda, to play that back again, sort of layman's terms, what I'm hearing is that like early days, it sounds like there was a lot of discussion about like similar, Google servers or whatever will be sort of trained on this data, or their engineers could pop into your email and, as part of debugging, look. And so is this sort of, does this waive privilege? And that eventually, and would love if you have an estimate of time, it sort of wound its way through the courts that no, that alone does not sort of waive privilege. But to your point, that doesn't mean that email is also automatically safe. How you operate within a company who, to Stephen's point, is CC'd, all of these things will still play a role. But, quote, just using an enterprise-wide license of Google Suites is not in and of itself destroying privilege. Do I kind of have that right? And do you have that estimate of like how long does it take to sort of find its way through the courts? And we will get on a webinar and you all will say like, oh, this is now 90% solved.
I honestly do not know how long that process took. Stephen was kind of nodding. Maybe he has a better idea of how that played out, that arc.
No, I just remember there were cases, and they're more modern ones too, on like just using the email, and the courts would look at like where it goes, and there were cases on. There was a more recent one. I think it was like in a divorce filing where the divorce attorney was emailing his client, but it was like accessible to the ex. The email was accessible, and the court found like it was unreasonable for him to be doing that. I think that wasn't as based in privilege. There's also the, on top of this, not to get too off field, there's the 1.6 ABA rule confidentiality, which is broader than different than attorney-client privilege. But there's also some cases on that too that talk about the sensitivity of the information and how reasonable it was to do that sharing. But I do remember some of those early cases on whether just using email in general and things like that were waiving privilege, which is interesting.
I will say this is showing up in our work with clients in maybe two primary capacities. One is, and this does go back to the question one of you mentioned about cloud services, that, as we have more and more cloud providers of our files generally, and more things are retained like on AWS or something like that, the idea that those also, they may be potentially privileged as regards AWS because of these prior decisions, but what you do with that access and control in your company still will also impact that. And then the other issue is that as we are now also engaging more and more AI-enabled services, clients, their first question out of their mouths to me, and I've seen several questions in the chat and in the Q&A about negotiating terms, is how will my data be used? How will this third-party tech provider have access to and or be authorized to use all of my data as their client? And it is a very key and threshold question, that you don't want your data being used for general training on their LLM or their model of whatever kind it is. If you want the opportunity to retain privilege and limit if you are using it for sensitive data and other kinds of concerns like that, you also want your internal enterprise version not to be training on your own data, even internally in a closed system, because that risks the leakage of it to other people within the company who wouldn't qualify under that need to know standard. But that is a setting that can be in place so that what you put in doesn't go into the training model and therefore isn't likely to leak out anywhere else. So these are all these threshold questions that companies are rightly asking. But we always do make sure we go to the next step and say, okay, but then again, let's assume we have our settings and our controls in place as regards the technology provider. What are you doing internally? What practices do you have in place for your individual employees? What communications controls do you have as far as shared documents inside your company? Do you authorize the sharing of information across your platform, so that, for example, if something like Copilot is enabled where it has access to email and SharePoint and Teams and these other things and can extract data from all of those and put those together, do you have things in place where privileged information would not be searchable or susceptible under that? And there's a lot of questions to ask as we sort of go down that process.
I think this is actually a perfect, Andrew, if you don't have anything else on this, the perfect segue to the next slide, where we are getting a lot of questions on like, okay, well, like, how do I negotiate terms? What do I need to be paying attention to? Brenda, you very fairly flagged in the prep calls that, again, this will not be a definitive answer that everyone will walk away with exactly a checklist for what they should be doing, because it is so situation dependent. But would love to kind of open it up to the panel for any of these particular best practices that you might want to call out, as well as why you think they're particularly important. I feel like we've been talking a lot about the idea of not using these quote free models because that doesn't have all the enterprise terms of service we've just been talking about. But let me just open it up to folks as to any of these that you want to particularly emphasize.
Yeah, if I could jump in on one, I think
Please.
in the clear policies, I think these are all great tips, but I'd also add, keep in mind the sensitivity of the information you're communicating. Although that really may or may not come to play in whether privilege is waived in jurisdictions, it's a practical consideration. If a client calls me and says, hey, when's our deadline to file a motion for summary judgment? Me responding is rendering legal advice. If they call me and say, hey, are we violating the Computer Fraud and Abuse Act by this activity we're doing right now, that's also legal advice, but one is way more sensitive than the other, and we'd be way more concerned if that got leaked than me telling them when their motions for summary judgment filings are due. So I'd say keep in mind, if this is something extremely sensitive, maybe use extra caution on things like that. But I think these are all good tips here. But I'd take like a practical risk-based approach on, what is it you're working on? What's the sensitivity level? And maybe craft your policies based on that, because there are some like legal tasks that are more routine. There are other things that, and we tend to know they're different by organization, that are more sensitive or could land people in, there could be a Wall Street Journal article on the front page if this got leaked kind of thing. And you should just keep those things in mind when you're determining, what information to put in AI and what tools and what not.
Stephen, I think that's a great point and kind of goes to the last best practice we have here, which is like everyone's understanding of those kind of more sensitive issues might not be the same. And so having organization-wide, legal team-wide conversations around what is your sort of most sensitive data, I think is a really smart practice, because, having been the new person in large organizations, sometimes it is not immediately obvious to everyone.
Sure.
Brenda, Andrew, any of these that you want to particularly highlight?
I can jump in on the first one.
Please.
So I think if there's like one takeaway here, it's this first item here, which is that you should not be using free AI models, anything without that you don't have an enterprise contract with, to work on anything privilege or even privilege adjacent. It's a bad idea, even if you think you're gonna set up policies for employees to not put that information in. Employees sometimes aren't going to be the best judges of what may or may not be privileged otherwise. And so just as a threshold matter, you should always be signing up for enterprise agreements with any LLM or other AI used internally. And then I could take the second, unless Brenda, do you want to speak to the specific terms?
Well, I want to just point out that for anybody, especially anybody on here who comes from a privacy, data governance, cybersecurity background, where you're focused on sensitive data, personal data, protected data, confidential data of any kind, you could take this same list and apply it to that. And in fact, if you kind of want to just think of privilege as one subcategory of confidential data or sensitive data, you would be well served. It has its own rules. So just the overall general approach may not be sufficient of protecting sensitive data or even personal data may not be sufficient, because you got to take those extra steps about the requirements for privilege. But if you think about it that way, you're at least going to be pretty well served to get further down that path, because these are all true for all of the kinds of data that you don't want shared or accessible or leaked or in any other way compromised or unduly accessed that your company is using. So if I could do a quick throwback to the beginning, where one of the questions was, do you trust enterprise? And the question was enterprise LLMs to keep your sensitive data protected. it was uniformly a no, I will tell you that most companies are planning for the use of enterprise LLMs internally to accommodate, like they're going to use it to look at employee information or to look at financial information or to look at other kinds of information that is sensitive or confidential within the company. And that's the whole purpose they want for it in many cases, is to be able to use it. And the whole value of an enterprise version of these is that you have these controls and settings. Now, obviously, some companies can take a more conservative approach and choose not to, but is to have these settings and controls in place so that you can use the enterprise version for these purposes and then also have your own internal security, privacy, and information management practices in place to retain other levels of internal protection for the sensitive data, including privilege. So I would focus, I'll give it back to Andrew to talk about some of the middle ones, but I would focus on the next to the last one just to make that point. Check the sharing settings. So anything you're doing with these, if you are having Teams meetings where it does a summary of the meeting, where does that summary go and get stored? Is it in some kind of SharePoint folder that everybody has access to? Then that's going to, very likely violate or waive privilege. If it goes directly to somebody who was in that meeting, who was one of the privileged parties, and they retain control of it, then it can probably, be considered to not have waived privilege or to retain privilege because it's a summary, but just as if they had taken notes themselves and then just had the notes. So context is going to be everything for this. But these kinds of settings and controls are the ones needed in place, and every provider is different, every contract is different, and every internal handling set of guidelines for a company is different, which is, even if the law was clear, is what would make this very complicated in a case-by-case basis. So Andrew, you want to add to that?
Sure. I do in a minute want to jump back to like the enterprise terms, but just on the idea of sharing, I think one important thing to consider that maybe many aren't, if they're using privileged material with an enterprise system even, is that any output you get from an AI that is based on privileged materials, you upload privileged material and you have it draft something else based on that. Even if it's not like obvious on its face that that information contains privileged material, I would have strict sharing policies against sharing that material with any third party and any also internal party without a need to know. So essentially the principle is if you're uploading privileged material for a chat, you should be treating all those outputs just like you would treat privileged material as well. Not saying they're privileged, but you should treat them like they are privileged, so you don't waive privilege. And
oh, go ahead, please.
I would just want to jump back just to
Yep.
reinforce on the enterprise point that when you're signing up for an enterprise agreement, you should definitely be reviewing the terms. And I think the most important term that you should be looking at, as I think we've reinforced throughout this conversation, is training. Essentially, anytime you see that an AI provider is training on your inputs, I would read that to yourself as like they are disclosing it to the public, essentially, even if they're not. I would treat that as having the same risk as disclosing it to the public. So ensure all your enterprise agreements restrict training, which almost all of them do today, and that there are also strict confidentiality assurances and limits on the company's use of your data outside providing the service to.
Andrew, that's very helpful because that kind of goes to many questions we got of how can you negotiate enterprise agreements, to maximize protection. And so it sounds like you're kind of really underscoring the no training, which as Don is putting into the chat, is really different from a consumer license and what you might see there. Okay, Ace, if you can go to the next slide. Please.
Oh, sorry. On the point you just made, let me just point out that none of this is simple or easy. Like talking about ChatGPT, for example, through OpenAI has multiple levels of individual paid versions as well as business versions. So they have what's called Teams, which is not at all confusing with their Teams meeting platform, version of ChatGPT, which is effectively a lesser enterprise version. It's for companies with needing less than 150 licenses, but it does have less protective options and controls. So even though that would be in many people's minds an enterprise version in the sense that it's not called enterprise, the one they call enterprise has the maximum amount of controls, but it's a business specific licensing platform for ChatGPT for your employees, it still doesn't have all of the controls necessarily available to you to do it, to use it for sensitive data or to retain privilege. So, you know, be careful out there.
Brenda, I feel like we should send everyone a bottle of wine after this presentation because many people maybe just like very their anxiety levels are going up as we speak. But I think that's a great point because again, like often, you know, a simple framework is a consumer or enterprise, but your point is that no, even within that, there are tiers and you really want to be careful there. Let's see, I'll quickly go over this point because I actually think the shadow IT usage is something to think about. So we've been talking a ton about risks of using these tools, but wanted to call out that there are, call it benefits, or if you want to think about it, there are also risks that I know, you know, I spend a ton of time with compliance leaders, with legal leaders. And one of the most consistent things I hear is that you all are under pressure from your senior leadership team to use AI to be more efficient. It's the whole organization's mandate, and therefore legal sort of needs to get on the bandwagon, for a very simplistic way to say it. And so I really, you know, just kind of wanted to underscore that you all are in a tricky position of sort of wanting to understandably support the team's mission, you know, align with your leadership, but also need to be identifying some of these risks. And I think that a risk that often goes maybe like is not as evident on first glance is actually the risk of not having an enterprise strategy to these really complicated issues, because shadow IT usage, just meaning that you know, yes, you may have a company-wide laptop, but next to it is almost certainly your employees' personal phones. And if they do not feel that they have the adequate tools to be productive and to get their tasks done, it is just highly likely that they are using a free version, a consumer version, you know, all sorts of things. And so, you know, just thought it would be helpful to make sure that that side of, call it the risk equation, is really brought out. Panelists, anything you want to add to here?
I do think it's really important to consider your company's culture and your expectations for your employees, how you want them to be able to operate, what kind of flexibility and capability you want to give them balanced against these risks. So again, to give an example, we have a client who the whole purpose behind getting an enterprise version of one of these models was to give, you know, greatly expanded opportunity and capability and you know, encouragement of innovation and engagement with these systems to their employees. And so their policy was written in a way that did not restrict the use of any company data, sensitive data, personal data, or anything else. And to counterbalance that, what they did as part of their mitigation strategy, given that they, first of all, because they knew their employees were going to do it anyway, in the nature of what their particular industry or business was, that was the point of having it. So they're going to allow it, but they had zero retention schedules set up so that no information was retained on these systems, and anything that the employee used it for and wanted to keep, they had to download and keep separately according to their normal security and protection policies, as a way of sort of balancing those risks. So there are a variety of things that you could put into place, both technical and policy controls, to try to finesse the outcome that you want. That is a balance of these risks versus the benefits you and or your employees may perceive from these systems.
Brenda, perfect segue into the last slide, and then I'll try to slip in probably one question because I think that's all we'll be able to get to, which is this webinar is put on by Ethena, and an approach that we have that we're spending a lot of time with our clients on is it's really important to communicate your standards. I saw a question, for example, how do you recommend structuring policies so employees know what is acceptable versus high risk? I think your training, your communications, and your policies are really where you're doing that, because this kind of all comes down to, like, these are complicated concepts, but that are going to be impacted by the day-to-day decisions of employees, the vast majority of whom are not lawyers. Even to Stephen's earlier point, even if you are a lawyer, these are complicated concepts. And so you really want to make it incredibly simple for a non-lawyer, that junior customer service rep who actually has a lot of your sensitive data, you know, to understand it. And so a couple of things we think about is really good off-the-shelf content on things like legal privilege 101, data privacy. Brenda, to your point, like many of these same foundational principles carry over from data privacy. And then making sure it's incredibly easy to customize it to your own policies. Do you want to be telling employees, you know, that like OpenAI is okay because we have this enterprise-wide model, but do not use X, Y, or Z other tool? that making it incredibly simple and clear is probably one of the best ways to just make sure that you've disseminated all the information that a legal team has. All right, we have 4 minutes left. I would say that the most common question was around note takers. And so I'll ask the panel to kind of briefly weigh on in this, recognizing that I think the answer is going to be something we talked about in prep, which is if you have them, should you be implementing company-wide precautions? And the TLDR, as I got it, but panelists tell me if you'd add anything to this, is yes. You want to look at terms of service, training data limitation, retention periods, and admin settings. And as one of you so eloquently put it, do not just accept defaults and let things ride. Note takers being just like an incredibly common tool being deployed like throughout organizations. But panelists, any last comments you want to give on note takers or really anything else, because we had approximately 1 million questions. Stephen, I can start with you and then go Stephen, Brenda, Andrew.
Sure, real quick. If you're thinking about, and we face in the cybersecurity area all the time, like Brenda kind of alluded to this earlier, if you make something too restrictive on employees, on something that they like to use, you're going to have people not just shadow IT, but people do things that are worse or more risky to an organization. It is not uncommon for me, like work with a client that does things like disable computers from being able to do screenshots. And then if you go to their facilities, you see employees with their phones literally like taking pictures of things from their screen and texting it to other employees, which is way worse. And so I feel like if you're going to restrict something that people, especially if they've already gotten comfortable using it, like note takers, I'd say come up with some alternative that's more secure or that's more likely to be used, but has some precautions built into it. So just be careful being overly restrictive, I guess is my advice there.
As someone who's in the Army and saw that principle play out daily of like, if you tell someone to do things in an incredibly cumbersome way, they will tell you that they're abiding by it, but they will not do that. I think that's a great point. Brenda?
I think the one point that I would emphasize that I think we've probably made pretty clearly is that there is no one size fits all for this. There, unfortunately, especially if you're in-house counsel, is not an easy checklist or setup that you can just sort of like take and plug in and be good to go. It's going to take understanding the tools you're using, whether it's LLMs or other more targeted and particularized AI-based tools, understanding what the terms and conditions and controls that are available to you are, understanding your own internal security controls and standards and policies, and then putting that all together in some kind of reasonable way to set up and then document what you have in place in order to, again, protect sensitive data, maintain good cybersecurity, and protect privilege. So all of that is going to be, at least partially on your shoulders as in-house counsel, or if you're outside counsel advising people, helping them walk through that and put together. I answered a question in the Q&A about acceptable use policies. Those are always very, very specific and targeted to the client. We always start with a template, like there's some things we know are going to be included, but they can't just be plug and play. So unfortunately, that is the way it is.
It's very fair. And Andrew, I'm sorry, we'll have to end here because I know that we have a lot of lawyers on this call who are probably triple booked for their next session. But I so appreciate everyone giving these panelists giving such thoughtful information. And if any of you want to follow up with them, we'll make sure in our follow-up email contact information is readily accessible so that you can pick their brain sort of more specifically. And thank you so much for the audience. It was a really active chat, and I just so appreciate everyone taking the time to learn about this with us. Have a great rest of your days.
Thanks, everybody.